If you've been injured, the law may give you more rights than you realize, but one mistake after an injury could cost you. In South Carolina, you can file a personal injury claim to seek compensation for the harms and losses you may have suffered if you were injured by the negligence of another. Here are 4 questions about South Carolina personal injury law and your personal injury claim that could mean the difference between walking away with nothing or recovering the compensation you may deserve. Number 1. How is personal injury defined in South Carolina? A personal injury is when you've suffered an injury to your body, mind, or emotions rather than damage to your property. South Carolina law looks at 2 things. Liability, was someone else's negligence responsible for your injury? And damages, if someone else was negligent and caused your harm, what were the nature and extent of your injuries? The answer to those questions can determine how much compensation you may be owed. Number 2, how does negligence work in South Carolina? Negligence means someone failed to use reasonable care in a situation that an ordinary person would use in those same conditions. South Carolina follows a rule called comparative negligence. This rule decides how fault is shared, and it can affect how much you recover in your personal injury claim. That means if you are less than 51% at fault, you may still recover compensation, but your damages are reduced by your share of the blame. For example, if you're found to be 20% at fault for the accident, you could potentially only recover up to 80% of the damages you've suffered. So comparative negligence doesn't erase your right to recover, but it does make proving fault very important. Number 3, what is the statute of limitations for personal injury claims in South Carolina? Timing matters. In South Carolina, you generally have 3 years from the date of your injury to file a personal injury claim. That means within 3 years, you must either settle with the insurance company or file a lawsuit. The sooner you act, the stronger your case may be. Witnesses forget, evidence disappears, and waiting too long could cost you money you might otherwise recover. This is why consulting with a South Carolina personal injury attorney right after your injury can help you recover compensation you could miss out on if you waited. And number 4, what types of personal injury damages can you seek compensation for in South Carolina? South Carolina personal injury law allows you to seek compensation for 2 types of damages. Economic damages like medical expenses, lost wages, and property damage, and non-economic damages like pain and suffering or loss of enjoyment of life. An experienced South Carolina personal injury lawyer can also help calculate future costs you may not be aware of, like ongoing care or lost earning potential. Do you need a personal injury lawyer in South Carolina? In my opinion, the answer is usually yes. At the law offices of James Scott Farron, we have the experience and resources to help you through all phases of the personal injury process, including the accident investigation phase, the medical treatment and recovery phase, the insurance company negotiation phase, the resolution phase, and the litigation phase if needed. When you've been injured, your focus should be on what matters most, your recovery. Let us handle the legal details and negotiations for you and fight for full compensation on your behalf. We will try to get you the money you need quickly so you can put this accident behind you. For a free case evaluation with no obligation, contact us by phone or online today. We are here to help.